Hello and welcome to The Big Picture. The decision of the Chief Justice of India to reject the invitation of the Prime Minister to attend a meeting to choose two eminent persons to be part of the National Judicial Appointments Commission has led to what, according to some, is a constitutional crisis. The Chief Justice, Justice Dattu, has made it clear in a letter to the Prime Minister that it is neither appropriate nor desirable for him to attend the meeting till the Supreme Court decides the validity of the National Judicial Appointments Act. A five-judge bench of the Supreme Court, headed by Justice J.S. Kehar, is hearing a batch of petitions questioning the validity of the government's notification of the Commission. The law was notified recently after the Parliament had passed it last year and 20 states had ratified it. The decision of Justice Dattu to stay off the meeting may lead to delay in appointments of several judges, including Chief Justices of the 7 or 24 High Courts. There are also many additional judges whose terms are coming to an end. Apart from these issues, the larger question is whether the Chief Justice of India has done the right thing by refusing to be part of the panel and attend the meeting. What are the implications of it, and how can this crisis be resolved? Is it leading to a confrontation between the judiciary and the executive? We will discuss all this today with Soli Sorabji, former Attorney General of India, P.P. Rao, Senior Advocate in the Supreme Court, Justice B.A. Khan, retired Chief Justice of the Jammu and Kashmir High Court, and Satya Prakash, Legal Editor, Hindustan Times. Welcome to all of you. Mr. Sorabji, do you think that the Chief Justice of India was right in refusing to attend this meeting?
No, I don't quite appreciate the reasons he gave for not attending the meeting, because in the first place, there is no stay granted by the court of any provision of the Act. Besides, it's his duty as much to sit in court as to attend the meeting. Because if he does not attend the meeting, the whole process will be stalled.
Right.
And many appointments which have to be made, or the appointments which are coming to an end, will be rather in a very nebulous zone. So I don't think he was quite correct. I don't understand quite the reasoning, but I think it's his duty to attend the meeting as so long as the Act is there and there is no stay granted by any court. I think he cannot avoid that.
He cannot avoid that. Mr. Rao? Mr. Rao, when he says that it is neither desirable nor, he says that it is neither desirable or right for him to attend this kind of this meeting, because he says that the entire validity of the Act itself is under question, that a five-judge bench is hearing this case, so how can I go and attend this meeting?
As I see it, he is feeling embarrassed to attend the meeting when the validity of the Act itself is under challenge in Supreme Court.
Right.
And hearing is going on. Yes, it is right. Legally, the correct position is, in the absence of stay, the Act is in operation, and all the functionaries who are required to act in order to choose the eminent persons, they will have to act in the absence of any stay by the court. So therefore, that is legal requirement. But then question of personal embarrassment, it is for individual to choose. If he feels embarrassed about it, you cannot force him to attend. That is the position.
You cannot force him to attend.
So, but then there is going to be a stalemate. You cannot force him to attend. It is. And then there is going to be a stalemate on account of this. Number of appointments will be held up. But then for that, the only solution I can think of is, has to come from the court itself on the judicial side. The judicial side, the court has to find a solution to this impasse and resolve it.
Judicial solution has to be found. Justice Khan?
What solution?
What solution? I'll come to you, Mr. Sorabji. I'll come to you. Justice Khan, what solution? The Attorney General has mentioned to the five-judge bench which is hearing this case, please direct the Chief Justice of India to attend the meeting. How will it look for five judges who are working under the Chief Justice of India to direct him to go and attend the meeting?
I agree. I don't think that Attorney General is conducting himself like an angry young lawyer for a
He is conducting, you're saying.
For a government, he must realize that he is holding a constitutional position himself. And he has to be very, very restrained while making submissions before the court, because he is the constitutional authority who in fact assists and guides the court. Now, he has been using expressions like unconstitutional.
Yes.
And
he has called the collegium system unconstitutional.
Unconstitutional. No, even this, the staying away of the Chief Justice of India, he has called unconstitutional. And some senior lawyers have also supported that theory, which I find very strange, because our constitution does not direct a member of the selection committee. See, what is the issue? Issue is Chief Justice of India is a member of the selection committee to pick up two eminent people,
right,
A and B. Now, one of the members chooses to not attend or stay away for reasons good, bad, or indifferent. But he is not violating any constitution, because no constitution directs a member of the selection committee to attend or not to attend. So therefore, his act could not be called unconstitutional before the Supreme Court by the Attorney General during the proceedings. That's one aspect of the matter. Second, as Mr. Rao was saying, it is the choice of a member of the selection committee to attend or not to attend.
Mr. Rao feels that he may be embarrassed to attend this meeting when a case is happening in the court.
Personal embarrassments are not relevant in the discharge of duties. See, personal embarrassments, one could understand that there was some kind of a stay order by the court. One could understand that there was some other legal problem coming in the way.
Yeah.
It's a different matter. But you can't be, to me it appears, he says it's inappropriate and not desirable. For me, it appears that his not attending is inappropriate in the sense that being the Chief Justice of India, he is holding a position, constitutional position. He could have gone and explained there before two other members of the selection committee that let us not rush through, wait for 15 days, the judgment may come or may not come. Otherwise, his staying away gives strange impressions in public perception. If you see today people saying that Supreme Court is mobilizing itself against the government on the issue, and a power struggle of sorts is involved. Now that impression can't be given by the judiciary, because tomorrow, if the judgment comes by the Supreme Court quashing this constitutional amendment and the act, this action of the Chief Justice will come handy in creating an impression that maybe
he has influenced the bench.
Maybe that the Supreme Court from the day one was wanting this act to go, because nobody wants to give away the power of appointment of judges. So government wants it to his side, the Supreme Court may want it to its side, but you have to strike a balance. You have to display some kind of statesmanship in these matters. And people who could have guided in those matters are appearing in the shows. Not in the So my take on this is that it is not unconstitutional, and Attorney General should not have used that word unconstitutional before the Supreme Court, though it may be inappropriate, as there was no valid reason for Chief Justice of India to stay away from a meeting. After all, what would have happened? Two eminent people would have been selected. It would not have meant any recruitment being made on the same day. So therefore,
Mr. Sorabji, the question, is this a constitutional crisis of sorts?
Yeah. Forget constitutional crisis, I want to ask Justice Khan, maybe the use of the term unconstitutional was not correct. I don't know whether Mr. Roti used it. But when Mr. Khan himself says, and rightly says, that there isn't any valid reason for the Chief Justice not to attend, then what's the consequence? What's the sequitur? He is part of the body so long as the act is not stayed, and unless there are personal embarrassments for some other reasons which you do not know. He cannot say mere pendency of the petition is a reason for him to stay away.
He has
and I don't understand why. Otherwise, in many cases, acts are challenged.
So he has no choice. Are you saying...
And the writ petitions are pending?
Mr. Sorabji, are you trying to say that he has no choice in this matter?
No choice in the sense that he should exercise the power given to him under the Act. Choice can be if there's a personal embarrassment of another nature, which is not disclosed, but not mere pendency of the petition, and it's being tried by the Supreme Court. On that reasoning, many things, many judicial functions will be discharged by different bodies. You know, in different acts there are provisions for judges to be on the board or the committee, and the thing is challenged. In other words, in one word, mere pendency of the petition challenging it is no valid reason for the Chief Justice not to attend.
Okay. Satyaprakash, how do you look at this? You know, what do you think will be the reaction of the government to this? You know, the government now is caught in a very tricky situation. If they go ahead, there are some suggestions being made by some people that this committee of 3 people can even meet if the Prime Minister and the leader of the opposition, the other 2 members of this committee, which has to select the 2 eminent persons, they both can meet, and you know, even if the Chief Justice is not going to attend, that committee can meet and select the 2 eminent persons. Well, is that some kind of a thinking which is going on in the government?
No, government, I don't know what the thinking is, but that would give an impression as if the government is hell-bent upon getting their own people into the committee. So that will not be the right thing to do. But having said that, I'll say that if the stalemate continues, the only solution lies with the Supreme Court, and the Supreme Court, by staying the Act, because so far the 3-judge bench and the Constitution bench itself, they have chosen not to stay the implementation of the Act. But if they stay the Act, then they will provide a legitimate ground to the CJI not to attend the meeting. And then during the pendency of the this petition,
but they have not.
Maybe for 15 days, they have said that everybody should complete the hearing arguments. But if the verdict comes within a month, then maybe it gives a legitimate ground for the CJI not to attend the meeting, and then everything can be sorted out. But having said that, to me, it appears to be a case of constitutional indiscipline. If the
constitutional indiscipline.
Because if the Constitution has vested some power in you, you are required to exercise that power. The Prime Minister cannot say that I will not chair the meeting of the cabinet. This is something which is unprecedented. A constitutional functionary is saying that I will not exercise this power, or I will not do this because I have certain reservations. Because as Mr. Soli Sorabji has rightly pointed out, the fact that certain petitions are pending against the NJAC, that cannot be a valid ground not to attend a particular meeting. Because as CJI, he knows that in must be hundreds of cases, he himself must have passed such orders, that since there is no stay, this has to be done. But how can he say this?
Mr. Rao, you know, one, is this a constitutional, Mr. Rao, is this a constitutional crisis? One. Second thing is, the CJI, the Chief Justice of India, has no choice in this matter. Do you think he has no choice in this matter? And can this meeting be held if they decide that, if the government decides, okay, as some people are suggesting, that, you know, let the meeting can be held, 2 members, the Prime Minister and the Leader of Opposition can sit and decide if the Chief Justice continues to say that, you know, he's not going to attend it.
Now, first of all, I would call it a constitutional stalemate.
Okay.
Not a crisis.
Right.
Now, so far as the Prime Minister and the Leader of the Opposition or the Leader of the largest party in Lok Sabha nominating the members is concerned, I do not think it will be in accordance with the constitutional provision, which is now the latest amendment which is under challenge.
Correct.
It requires 3 persons, particularly representing the judiciary and the Leader of the Opposition and the Prime Minister, all 3 of them to act together. If that is the mandate of the Constitution, it will be a violation of the Constitution if 2 of them, both representing the political parties, and which in other words will be a present government and a past government or a future government, and which represent the executive broadly, making the appointments. I think that would be against the basic structure of the Constitution. That will go against the concept of independence of judiciary, which is the core of basic structure. So that will lead to greater complications. So therefore, I do not advise that such a course should be taken by them. It would be very imprudent.
Okay, but Mr. Sorabji, I want all three of you to talk about this. My question is this. By taking this stand, the Chief Justice of India do you think has put additional pressure on the bench which is hearing these petitions? Now, because as some of you have pointed out, whatever stand they take can result in people attributing motives?
No, look, people can attribute motives for various reasons, good, bad, or indifferent. But I entirely agree, two people mustn't go with it in the absence of the Chief Justice.
Right.
Because after all, the judicial presence has to be there. The ideal solution would be if the whole thing can be decided within 2 weeks and judgment pronounced, reasons to be given later. That's an ideal thing. But it takes time. People argue. There are several counsel arguing for different parties. But the ideal would be if the bench says, suppose it's strike down, end of the matter. It opposes it, very well, that there's no reason for the Chief Justice not to attend. They can give their conclusion and say reasons to follow, and that can be done within 15 days. That would be ideal, though difficult.
Mr. Rao, would you agree with that? Do you think the Chief Justice has now put additional pressure on the bench also?
No, I don't think anybody can put pressure on the bench. The judges are independent. Judges are independent. Once the Chief Justice constituted a bench, he has absolutely nothing to do with the bench. The bench will not act under any pressure, even if the Chief Justice of India. And they will act on their own. What they think is right, they will do it. They are not going to be cowed down by anybody's pressure, not even the Chief Justice of India. That is the way the judiciary functions. That is what is meant by judicial independence.
Right.
That's why we have been fighting for the independence of judiciary all through. So that's a very core value of the Constitution. So I don't think you will be able to put any pressure on the judiciary. But one thing can be done. In view of the stalemate, somebody can move that very bench which is hearing the matter to find an interim solution. And that is possible for the bench to do it on the judicial side.
Mr. Justice Kehar, who is heading that bench, has already made a
solution, B.P. Rao.
Yes, Mr. Sorabji?
Beg pardon? Beg pardon?
No, I'm asking my good friend P.P. Rao, whom I highly respect, what solution do you think the bench can do except to really expedite the hearing and give a judgment in the shortest possible time? At least give the conclusion, the reasons that follow later.
One possibility.
Otherwise, what else can they do?
That is one possibility. That is one possibility. Another possibility is if any of the parties which are before the court, if they move the court for an interim relief, for interim arrangement, court could think of making an interim arrangement so that the stalemate is avoided, appointments can be made in the interim.
Okay. Yes. Justice Khan? Solution.
Girish, it's not a question of a solution.
Solution to the stalemate, what will happen later?
There can be sky is not going to fall in 15 days or anything. And what is the ultimate fallout? About 12 additional judges may not get appointed. And in case there is some desperation in their appointment continuation, as Mr. Rao was suggesting, somebody can approach the bench and say that their continuation may be ordered. So that's not the issue. Issue is that the attitudes which are being adopted are in all likelihood going to give rise to some kind of a conflict situation between the Supreme Court and the government, which is to be avoided.
Confrontation situation.
Confrontation situation. Conflict situation between the two organs of the government and
organs of
the state. And God forbid, we may fall back on bad days, those days when the voices were raised of a committed judiciary and so on and so forth. Therefore, we have to be very, very careful both sides. We have a government with a large mandate, and who knows if it rides roughshod tomorrow. And in spite of our saying that judicial element must be there, may not have be there. In 3-member selection committee, he might decide to go ahead, which is going to create a very, very awkward situation, a grave situation. So therefore, what needs to be avoided is that there should not be the conduct, the actions of both sides should be such as not to give rise to public perceptions that it's a war going on between the judiciary and the executive. Number one. Number two, answer to your first question, whether Chief Justice's action has created a pressure on the bench, answer is no. No bench, no court admits of any pressure in its judicial functioning.
Ideal situation.
In its judicial functioning, be that coming from whatever court. So there is no likelihood of any pressure being put on a bench how to decide and how not to decide. But what I am all worried about is, if it is carried forward, we will have a constitutional crisis. From constitutional stalemate,
it can lead to a constitutional crisis.
It can lead to a constitutional crisis.
Mr. Rao, my question is this: what has led to this situation? Let us, very briefly try to understand what has led to this situation. If I remember correctly, last month itself, before this act was notified, there was a challenge about the validity of this act. It was before the Supreme Court. Then it was said that since the act has not been notified, we cannot discuss and decide this. The government decided to notify the act even as the judiciary was not very comfortable about this whole thing. You think that the government should have waited for this whole thing to be decided at the judicial level before notifying the act?
I think the Supreme Court should have decided the validity without waiting for the notification.
Right.
Once Parliament has enacted the law, Parliament amended the Constitution, there was no impediment in examining the validity of the act at all. They did not have waited for the enforcement of the act by notification.
Right.
After all, validity of act doesn't depend on the notification.
Right.
I think court was not right there in deferring the hearing and then waiting for the notification.
Mr. Sorabji?
Otherwise, this kind of impasse would not have happened at all.
Absolutely. Mr. Sorabji, would you agree with that?
Yeah, I'm inclined to agree with P.P. Rao. But now we have to find out a solution.
Yes, that's right. We have to find a solution.
And the solution will be that
So here is a situation.
That the court can do by deciding the matter.
Yes, please continue, sir.
Within a fortnight, by deciding, I mean not to give their conclusion.
Sir, I don't know whether...
Act is valid,
no,
invalid.
you have...
Reasons to follow later.
You have enough experience than anybody else here. Whether the bench can decide in 2 weeks' time. There's so many hearings. Satyaprakash, today I'm told that there is also a talk of referring this matter to a 9-judge bench.
Yeah, a larger bench.
A larger bench, which means that it can get further delayed.
Further delayed, and because 9-judge bench, once it's constituted, if at all it is, then it will start de novo hearing, a fresh hearing.
Exactly.
But having said that, there is a solution, interim solution, that first the Supreme Court can, in case of additional judges, the Supreme Court can extend.
Yes.
Yeah, by judicial order, their appointment their tenure can be extended.
No, but as far as appointment of Chief Justices are concerned, they can't do it.
They can't do it.
Yes.
But
there are 7 high courts which doesn't have a Chief Justice.
So there is a crisis. Maybe there are people who are not terming it a crisis. They are saying it's a stalemate. There is a crisis. And this is an unprecedented situation where the CJI has refused to be part of this entire process. This law is new, but imagine if collegium system was there and the CJI or maybe some senior judges, they say, no, we don't attend. Or I said, the Prime Minister says, I will not chair the cabinet meeting. This should not be done. To me, it appears to be a case of constitutional indiscipline. Anybody who has been given constitutional power cannot behave like this.
Justice Khan, as far as the collegium system is concerned, it's over. I mean, it's a dead act.
Technically.
It can't be revived.
Technically, if you again ask the Supreme Court to extend judges' appointment, it comes back.
It comes back. So, this is again a constitutional crisis. Who will, if the judges, term is to be extended, who will do it? Who can do it?
Right now, only court. Somebody has to approach the same bench saying that now 12 judges or 50 judges, their terms are expiring. They'll be on the road tomorrow. So they might pass a judicial order and say continue them. So that is one way, and power goes back. Now, what I say...
No, just Mr. Sorabji's solution that, do it in 15 days, and even if the reasoning is not given, pass an order in 15 days. Do you think that in this kind of a situation it's possible?
That would be decided like this. They have to hear everybody in detail.
And there are a lot of people who are appearing for this.
This is not some kind of interim order, some small stay demolition of building.
Yeah, but
This is a serious issue. If people want to be heard, this constitution bench must hear everybody in detail, and then only the judgment should come.
See, yes, that would be a Girish ideal situation. Within time limitation, the Supreme Court can decide the matter. Then one would say the best solution is that government must exercise restraint and wait for another 15-20 days. Don't take any action. After 15 days, the whole thing will be clear. But imagine a situation where the matter gets delayed for one reason or the other. Maybe, for example, if it's a reference to 11 judges bench. Exactly. You have the 11 judges availability. Then you have so many lawyers being heard. Then you have writing of the judgment. Now, then you have other things coming in which are not to be talked on the show. Similarly, there is no guarantee, there is no certainty that such a thing can happen in 10-15 days. So, best thing for, according to me, would be that let us not allow it to be a precedent that Chief Justice of India will stay away from a meeting today. Tomorrow, again, some Chief Justice of India would stay from a meeting which can result in a crisis. Let Chief Justice of India see reason. Attend this meeting. What will happen? Nothing will happen. Two eminent people, or he may say, we will not select them.
Okay. Mr. Sorabji, do you think that the Chief Justice of India, having taken the stand which he has taken, having written to the Prime Minister what he has written, do you think now he can go back on what he has done?
Why? A person can always reconsider his decision.
Yeah, what is there? No prestige involved in function.
And he may have second thoughts about the matter in light of thinking of people about this matter. And by the way, all this thing about 7 judges, 9 judges, that's not media speculation. Let's not go into that.
No, apparently...
And the question is, I know it's an important matter, but the hearing is day to day.
Mr. Sorabji...
One minute.
Sorry.
Hearing day to day.
No, sorry, Mr. Sorabji. Sorry to intervene. There was apparently a mention of this in the hearing, during the hearing in the court today about whether the matter should be referred to a larger bench. It came up in the courts today, that's why I am mentioning that.
But did they mention who will refer to the larger bench? The Chief Justice. Who can refer it? But suppose a person says refer, it doesn't get referred.
Same bench.
The same bench.
Same bench. Larger bench, why this bench can't do it?
The same bench can't do it?
It has to be referred by this bench.
Unlikely. Very unlikely.
Okay. Okay, Mr. Rao. Mr. Rao, so final words to you. Do you think that the Chief Justice of India, having taken the stand which he has taken, can go back on it and now resolve? Because that seems to be the only way to resolve the crisis. Or do you think this 5-member bench can, as some people have suggested, that direct the Chief Justice of India to attend this meeting?
No.
You see, I don't think the five-judge bench can compel the Chief Justice of India to attend the meeting. That may not be possible. And the only right solution to me is to bring the difficulties arising out of the stalemate to the notice of the bench which is hearing the matter, and ask the bench to find an interim solution for this problem. And the ideal solution, I agree with Mr. Sorabji, is expeditious hearing and then giving the outcome of the decision and giving the reasons later. That can be done. It has been done in so many cases. Supreme Court has done it. Pronounced the operative portion of the order, whether it's valid or not valid. Then the reasons we'll give it later. That can be done. But that's the ideal solution. But that is not the only possibility as I see it. There is every possibility of the hearing extending. In the meantime, public interest should not suffer. Therefore, the proper course would be for one of the parties appearing before the court to bring to the notice of the court the consequences arising out of the stalemate and ask for appropriate interim directions from the court. That can resolve the problem.
Okay,
Executive cannot solve the problem. Parliament cannot solve the problem.
Okay, sir. I think on that note we need to end. But as all my panelists have pointed out, you call it a stalemate or a crisis. There is a problem which is right now before all of us. How the judiciary, as all my panelists again say, that only the judiciary can find a solution to it. We'll wait and see what kind of a solution can emerge in the present circumstances. Thanks to all my guests. Please keep watching. We'll come back with another issue, The Big Picture, same time tomorrow.